Please take your seats. Good afternoon to all of you and good afternoon to all those who have joined us online. So friends, from today we will start our current affairs class. Now before we start actually the things related to current affairs, let me tell you a few important points here. First, current affairs is something which is non-negotiable. You cannot just neglect current affairs, right? I hope all of you will agree with me when I say this. Current affairs is something which is completely non-negotiable. Secondly, in the preliminary examination over the years, especially in the last 2 to 3 years, you will see that so many questions have come directly or indirectly from things that were relevant in the news. So that's why it becomes very important for us to cover the current affairs part when we are appearing for the preliminary examination. Having said that, the two major problems which I feel aspirants face with respect to current affairs is, first is the vastness of current affairs. You know that almost everything that is under the sun comes under the ambit of current affairs. So it becomes really difficult, if not completely impossible, to cover each and everything related to current affairs. The second most important challenge is how to streamline your content with respect to current affairs. You don't know that there are so many aspects to current affairs, like say for example science and tech, environment, say economic affairs, international relations, political news, especially related to constitutional aspects, all those kind of things, and you do not know how to streamline all of that. So our effort in this batch would be to address both these questions. First, the vastness of current affairs, and secondly, to streamline our content. Now what I have done is I have divided this entire section into 18 thematic classes, and each class is dedicated to one particular theme, though there will be some topics which will have kind of importance in several classes. Like say for example electoral bonds, say for example, it will have significance in several classes. But in a particular class, my attempt is to stick to the core theme of that class. Like today, our class is on Supreme Court's judgments that are in news in the past 2 years. The time frame that I have taken for this batch is 2 years. It means I'll be covering everything starting from January 2023 to January 2025. Okay. Obviously, even after this, you will see there can be some here and there current related developments that I will give you in the form of some handouts. But mostly the chunk of current affairs which is relevant for the preliminary examination will be able to cover in these classes. And you see that roughly you can expect say 11 to 12 questions which come from current affairs or have a variance of current affairs integrated in them somewhere, or they are integrated with conventional questions. If we add all of that, then number goes up to 20, 22, something like that. But purely 10 to 12 questions from current affairs, you can just hands down expect that in the preliminary examination. And that's why we are doing 18 classes, and suppose on an average if I say we cover 12 to 14 topics every day in the class, so we are somewhere sitting more than 200 topics and 200 high probable topics. That's what my attempt is in the class. Now one basic pattern, if you see, if you analyze the previous year's questions with respect to the civil services preliminary examination, you will find that those events that have been in news for a considerable length of time has been picked by UPSC when it is framing questions. It means that those issues which have lingered over few months, or those issues that are very important either from the economy's perspective or the security perspective, or it's a breakthrough for India, like say for example India's manned mission or something like that, right? So if it's a breakthrough, then also it becomes very critical for the examination. Okay, so I hope you have understood the modus operandi of this class and what we are trying to do. At the end of the class, obviously I'll supply you the handout that we'll be discussing in the class today. So what I want from you people is that you relax, you don't feel, you don't take a lot of stress, right, related to current affairs, because when it comes to current affairs, there's a lot of stress among aspirants because they don't know that what to study and what to leave. But a disclaimer that I want to give to all of you, हो सकता है कि सारे क्वेश्चंस हमारी इन क्लासेस से आ जाए, हो सकता है कुछ ना भी आए. You understand that? Because the only thing certain about UPSC is its uncertainty. All I'm trying to do is that this is what logic, common sense, experience tells me, that these are the important topics as far as the current developments in the national and in the international arena are concerned. Okay, so our first class is the Supreme Court judgments, the major Supreme Court judgments that have had ramification in the past 2 years. So without further ado, let's get started. Let's pick it. So we start with Jallikattu. Now the Supreme Court has passed a historical verdict on Jallikattu. Now, if you are not aware about Jallikattu, what is it? It's actually a bullock cart race. Do you understand that? Or it's actually a bull race, which is performed in the harvest season in Tamil Nadu, obviously during the occasion of Pongal. Now, several animal activists and several intellectuals, they have argued that this entire practice goes against animal safety, security, or amounts to cruelty against animals. On the other hand, there are people who have supported the practice of Jallikattu on the ground of cultural heritage. Okay, so there was a clash between those who wanted to support this practice of Jallikattu and those who were against this practice of Jallikattu. In simple terms, Jallikattu is where a bull is allowed to run free, and people, they jump over the bull, they hold it by its hump or by its horn, as you can see in the picture, and they try to tame it or bring it under control. And this is mostly done during the harvest or after the harvest when the Pongal is celebrated. So this is a age-old practice in Tamil Nadu. Similar kinds of games are also conducted in states like, say, Karnataka, where it is known as Kambal, where a pair of buffaloes, they are allowed to run through wet paddy fields, often one after the other, and the people, they try to control it, or you can think of, there is a jockey who tries to control the fast moving buffaloes. Okay. Similarly, in Punjab, in Maharashtra, you will have similar kind of arrangements as well. So depending upon what kind of livestock is available in that region, the game has modified, and mostly it is conducted during the harvest season. Okay. So in this game, there is an argument that when people try to control these animals, because these animals, they are running with ferocious speed, when people, they try to control these animals, they often inflict injuries on the animal, and that amounts to animal cruelty. Okay, and which is against the Prevention of Cruelty Towards Animals Act. Okay, so this is why Jallikattu became a bone of contention between those who were standing for animal rights or wanted for animal protection, and those who felt that it is part of cultural heritage. Okay, the entire matter went to the Supreme Court of India. The Supreme Court of India said that Jallikattu is actually against animal interests or the interests of animals and amounts to cruelty towards animals. And obviously, following this judgment of the Supreme Court, there were wide scale protests, especially in Tamil Nadu, and therefore the Tamil Nadu government brought an amendment, and this amendment created several safety measures and safeguards for the animals, and this amendment was challenged in the Supreme Court of India, and the Supreme Court of India has declared this amendment made by the Tamil Nadu government as valid. It means the practice of Jallikattu has been reinstated in the state of Tamil Nadu. Obviously, Karnataka High Court had also declared the Act of Kambala as unconstitutional following the judgment of the Supreme Court with respect to Jallikattu. But having the new verdict in mind, the practice of Kambala has also been reinstated in the state of Karnataka. But except Karnataka and Tamil Nadu, such kind of sports are now banned throughout India because no other state has brought any such kind of amendment. Okay, so this is the first topic. Do you understand the background? Okay. So, in a 2023 verdict, the Supreme Court of India has upheld the practice of Jallikattu as permitted by the 2017 Tamil Nadu Amendment Act related to Jallikattu. Now, what is Jallikattu? Jallikattu, a traditional bull taming sport in Tamil Nadu that has been the subject of extensive legal scrutiny concerning animal rights and cultural heritage. The sport involves releasing a wild bull in a crowd of people, and the participants attempt to grab the bull's hump and ride it for as long as possible, attempt to bring it under control. It is celebrated in the month of January during the Tamil Harvest Festival, Pongal. Okay. Now, Supreme Court's 2014 verdict on Jallikattu, if you see that, in May 2014, the Supreme Court of India in Animal Welfare Board of India versus A. Nagaraja case imposed a ban on Jallikattu. The court determined that the practice violated the Prevention of Cruelty to Animals Act 1960, citing inherent cruelty to bulls involved. Now, when we talk about a civilized society, obviously we must recognize rights belonging to every species. Do you understand that? And the rights should not be limited only to humans, but such rights should also extend to non-humans as well. This is the mark of a civilized society, and that's why you see that there were activists who felt that these kind of practices, they are going against the rights of animals, and they also amount to cruelty against animals. And in the name of these cultural practices, there was a lot of atrocities that were being committed on animals. Now, this is only one aspect of the story, or one side of the story. On the other side, there were people who said that Jallikattu is an integral part of culture, and the bulls, they are treated with respect. In fact, if we ban the practice of Jallikattu, then all the efforts which go in the upkeep of the bulls in their breeding and all those kind of things will take a back seat. In fact, bulls will then be mostly roaming in the streets and they will die out of starvation. Further, cultural practices are also part of cultural rights, and therefore, in the name of judicial intervention, you cannot completely throw away the cultural aspirations of the people. The people who were supporting Jallikattu, although acknowledged that yes, there are some problems, and in several villages during the celebration of Pongal, it was reported throughout Tamil Nadu that there were atrocities, some atrocities committed against the animals. But they said that for that we must have safeguards. It's like, say, for example, that the road is dangerous and therefore nobody should ride on the roads on vehicles. Do you understand that? So, it's as simple as that kind of an argument. So, those who favored Jallikattu said that it is a part of Tamil Nadu's culture, and therefore, the cultural aspirations of the people. Further, it is a constitutionally granted fundamental right. Look at Article 29, Clause 1, which says that any group of citizens who have a particular culture have the right to protect the same. Do you understand that? And on that ground, they said that the celebration of Jallikattu should be continued, although they acknowledge that there are certain problems with the present oversight or the present regulation of the event, and there could be more safeguards that could be incorporated. Anyhow, the 2017 legislative amendments and protests, once the Supreme Court declared Jallikattu as null and void and unconstitutional, then in 2017, in response to the Supreme Court judgment, there was wide-scale protests in Tamil Nadu. And then the Tamil Nadu government enacted the Prevention of Cruelty to Animals Tamil Nadu Amendment Act 2017. This amendment aimed to permit and regulate Jallikattu, asserting it is an integral part of the state's cultural heritage. So I hope you are understanding the argument. On one side, there are people who are batting for animal rights, animal protection, who are against the commission of atrocities against animals. And on the other hand, there are people who are celebrating culture, who are celebrating aspirations of the people, who are also not in favor of completely banning something which has continued for ages. Do you understand that? So what are the constitutional provisions related to this case? Obviously, Article 29, Clause 1, which says citizens with a distinctive language, script or culture have the right to preserve it. This is cultural and educational rights, which is part of fundamental rights, so therefore cannot be taken away. This is the argument. Article 48, which is a part of Directive Principles of State Policy, says that the state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and in particular take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. So here also you see that no kind of atrocities should be committed against animals, and animal breeding should be conducted in, say, on modern scientific lines. And then there is a fundamental duty which is contained in Article 51A, Clause G. Citizens should protect and improve the natural environment, including forests, lakes, rivers and wildlife. Citizens should have compassion for living creatures. So this part, citizens should have compassion for living creatures. This is one argument which is often raised by animal activists. They say that this practice of Jallikattu may go against the interests of the animals. So two thoughts clashing against each other, two ideologies clashing against each other. One claiming that these kind of practices commit atrocities against the animals. They amount to cruelty against animals. Whereas the other thought which says that this is an age-old cultural practice and there could be some flaws in it, but we should not completely eliminate it. Do you understand that? So this is the argument. Similarly, Kambal. Kambal is also a similar kind of race conducted in Karnataka on the lines of Jallikattu. So Kambal is a traditional buffalo race held in the coastal district of Karnataka, especially in Udupi and Dakshin Kannada. It's a rural sport in which pairs of buffaloes controlled by a jockey race through a muddy paddy field. Now Kambal came into news or became a point of observation, especially when a Kambal jockey, on the internet he went viral because he completed a 100-meter sprint in 9.55 seconds, which is very close to the world record held by Usain Bolt. So that's why a lot of attention was then diverted towards this game Kambal. Now in one of the movies, like there was a famous movie where this game was also shown, okay, this Kambal game. But anyhow, so be it Jallikattu, which is mostly by bulls, and Kambal, which is by buffaloes. It is mostly with respect to the harvest season. Both these things, they are races, cart races or single animal races, and people, they try to control the animal, tame the animal, and in all of this there is cultural sentiment intertwined. Okay, it was banned by the Karnataka High Court, obviously following the Supreme Court judgment, but after the Tamil Nadu Amendment Act was upheld by the Supreme Court, practice of Kambala has also been reinstated now. So now what is the situation? The situation is, except in Tamil Nadu and Karnataka, where bull taming and racing continue to organize, these sports remain banned in all other states including Andhra Pradesh, Punjab and Maharashtra due to 2014 ban order from the Supreme Court. Okay, so this was our first topic. So when it comes to what is more important? See, If we are discussing the same topic with respect to mains, then we will go into the details of the banning, right? The merits of banning, the demerits of banning, what is the way forward, all those kind of things. We will not venture there because our focus is the preliminary examination. So what you need to do is, there could be question directly with respect to Jallikattu. What is Jallikattu? Which of the following statements are correct related to Jallikattu? Or there could be questions with respect to the Supreme Court's verdict on Jallikattu. There could also be questions related to, in the game of Jallikattu, which of the following constitutional provisions can be invoked with respect to the game of Jallikattu. Like say for example, as I have already highlighted this to you, that Article 29(1), Article 48, Article 51 AG, all can be seen in the light of this game Jallikattu. Okay, so this was our first topic, Jallikattu, a race or a bull race which is generally organized during the Tamil harvest festival of Pongal, and in 2014 the Supreme Court banned it because some animal activists, they claimed that this amounted to cruelty against animals. Then there was the amendment done by the Tamil Nadu government, adequate safeguards that were taken, and Supreme Court now is satisfied with these safeguards, and Supreme Court also understands that in the name of judicial intervention you cannot completely obliterate a cultural practice, because educational and cultural rights are also fundamental rights. Do you understand that? Are you clear with the first topic? So this is our first topic. Any doubts? Okay, so let's move forward. Supreme Court has given a verdict on Article 19 and 21. I hope you are aware about Article 19. Article 19 grants to citizens a set of freedoms. What are they? Freedom of speech and expression, freedom to assemble peaceably and without arms, freedom to form associations, unions and cooperative societies, freedom to move throughout the territory of India, freedom to reside or settle in any part of India, freedom to practice any profession, carry on any occupation, trade or business. All these freedoms are available only to the citizens. Do you understand that? And they seek to establish what? Civil and political liberty in India. Dhyan rakhna. Article 19 establishes civil and political liberty in India. Article 21, which deals with right to life and personal liberty, it is available to not only citizens but also non-citizens. It means it shall be available to anyone on the soil of India or within the territory of India. Now, Article 21, which is right to life and personal liberty, is a basic human right. याद रखना, जैसे Article 19 is mostly civil and political liberty, Article 21 is a basic human right which cannot be taken away under any circumstance. So it's an inalienable right. If there is a right which is inalienable, it is right to life and personal liberty. Yaad rakhna, this is also recognized by the United Nations Universal Declaration on Human Rights or the Human Rights Charter. ठीक है, अब देखो Article 19 और Article 20 अब से पहले तक they were available only against the state. It means that if the state violates your freedom of speech or expression, or if the state arrests you and thereby distorts your liberty or something like that, then you can go to the Supreme Court of India and file petition for obtaining appropriate writs under Article 32, which is nothing but right to constitutional remedy. Suppose a private individual incurs any harm on another private individual, then this constitutional remedy was not available. You may have the right to take recourse to ordinary legal remedy, but no constitutional remedy. Constitutional remedy means you can directly move the Supreme Court. This was possible only when Article 19 or Article 21 has been infringed by state action. Now, what is state? That is also clearly defined in Article 12, and Article 12 says this will be state for the purposes of Part 3 of the Constitution, which is nothing but the part on fundamental rights. The same definition also works for Part 4, which is directive principles of state policy. So, what is state? State amounts to the legislative and the executive organ of the union, the legislative and the executive organ of the states, the municipalities, panchayats, district boards, etc., local authorities it means, and other authorities. Other authorities means any other authority which has the right to make rules, guidelines, bylaws, etc. Like say for example, RBI, SEBI, these all would amount to other authorities. Even the Supreme Court has said that the action of an individual will become the action of the state if it is backed by the state. Even private actions will be construed as state action if they are backed by state support. Suppose you are doing something, but you have the backing of the state administration, or suppose the district administration, then your action will also amount to state action. Do you understand that? The judiciary is not a part of the term state when it is acting judicially or when it is trying to act in its judicial capacity. But when it acts in its administrative capacity, then it becomes a part of the state. याद रखना, जैसे कि सुप्रीम कोर्ट में अगर कोई रिक्रूटमेंट हो रहा है, सुप्रीम कोर्ट में कोई अलॉटमेंट हो रहा है, ऐसा कुछ हो रहा है, then it becomes part of state. But when Supreme Court acts as an adjudicating body, it is giving judgments or it is issuing guidelines or it is doing judicial activism, etc. It is not considered as part of state. ठीक है, तो एक चीज जो है वो कॉन्सेप्ट होती है हॉरिजॉन्टल एप्लीकेबिलिटी ऑफ फंडामेंटल राइट्स एंड vertical applicability of fundamental rights. Vertical applicability of fundamental rights means that if your fundamental rights are infringed by the state, state is above you, so if it is infringed by the state, then you have the constitutional remedy path. Horizontal applicability of fundamental rights means now even if another private individual infringes upon your basic freedoms included in Article 19 or hurts your life or liberty under Article 21, you have the right now to go to the Honorable Supreme Court of India. This judgment of Supreme Court is a landmark judgment because it actually establishes Article 19 and 21 as universal fundamental rights. It means they are now context independent. Before they were context dependent. It means they can be enforced only if they are infringed by state action, whereas now they can be enforced even when they are infringed by the action of private individuals. Isn't that a great news for each and every one of us, thanks to the observation made by Supreme Court of India. So let's see this news as well. In Kaushal Kishore versus State of Uttar Pradesh, the Supreme Court ruled that fundamental rights under Article 19 and 21 can be enforced against private entities also, not just the state. Here I have given you the meaning of Article 12 with respect to fundamental rights, or what is state. Article 12 of the Indian Constitution defines term state for the purposes of Part 3, which is fundamental rights. It includes government and Parliament of India, includes central government and both the houses of the Parliament, means Lok Sabha and Rajya Sabha. Government and legislature of states includes state government and state legislative assembly / council, because all states are not bicameral. Local authorities includes municipalities, panchayats, district boards, town planning authorities, etc. Other authorities includes bodies under the control of government, like statutory bodies like LIC, ONGC, etc. What about National Human Rights Commission? Will that be also a part of state? Will that be also part of state? Yes. Government controlled companies like ONGC and all. Universities and public institutions like say Delhi University, will that also become a part of state? Any organization performing public duties under government control. Now the Supreme Court and High Courts, when performing administrative functions, example hiring staff, managing budgets, are considered part of state under Article 12. But when they perform their judicial functions like delivering judgments, interpreting laws, they are not considered state under Article 12. ये आपको याद रखना है, ठीक है? So are the courts part of the state? Yes and no. Yes, when administratively they are acting. No, when they are acting in their judicial capacity. Okay. Now, subject matter of Article 19 and 21. Here I have given you a quick comparison chart. Freedom of all the 6 basic freedoms, and that is right to life and personal liberty only to citizens, to all persons, citizens and non-citizens. Government can impose reasonable restrictions on all of them, but that can be curbed only on the ground of procedure established by law. But you know that in Maneka Gandhi case, Supreme Court has discovered what? Due process in Article 21 as well. I am not going to go in detail of that because that is traditional polity. Nature is, this is political and civil liberties, that is basic human right that you have to keep in mind. Now, what is the significance of Supreme Court's verdict? Look here, it signifies a shift from purely vertical application of fundamental rights to horizontal application. This ruling implies that an individual's right under Article 19 and 20 are protected not only from state interference, but also from actions by other private citizens that may infringe upon this right. Okay. So, it establishes two things. This judgment establishes two things. First, it makes Article 19 and 21 universal fundamental rights. Do you agree with me? And they are now context independent. It means whether in the public context or in the private context, they can be enforced. And secondly, it imposes a positive obligation on the state to ensure that even in private sphere, there is no infringement of Article 19 and Article 21. Do you understand that? So, this is an excellent topic, by the way, for mains written examination as well, and there could be question with respect to this topic. But having said that, when it comes to the preliminary examination, तो इस topic से आप कैसे question expect कर सकते हो? First, obviously, the meaning of state. There could be a question related to the meaning of state because this is in news, so that's why there could be a question with respect to this. So यहाँ पे आपको बस दो ही चीज याद रखनी है. क्या याद रखना है? That judiciary is part of state and not part of state. Depends upon the context, and even the action of private individuals will be considered as state action if backed by the state. You have to keep those two things in mind. Secondly, there could be a comparison between Article 19 and Article 21. Although in the real examination you will see very straightforward questions, right, with respect to Article 19 and 21 in the previous years, but still there could be a question on this. So keep this in mind, that first thing is that this is available only to citizens, that is available to both citizens and non-citizens. This establishes political and civil freedom of speech and expression. Is it necessary for asserting your political right in a democratic setup? Yes, but right to life and liberty, this is basic human right. Even if it is not a democracy or it's any kind of political setup, you require this basic right, otherwise you will not be able to reach your potential, or you will not have the power of self-actualization, self-realization, etc. Okay. So that's one thing. Third question that could come in the preliminary examination from this topic could be with respect to vertical application of fundamental rights and horizontal application of fundamental rights. So there could be a question like, which of the following fundamental rights have both vertical as well as horizontal application, or which of the following fundamental rights have only vertical application, which of the following fundamental rights have only horizontal application. So most of the fundamental rights have vertical and horizontal application, but some of them are exceptions. Do you understand that? So I leave it to your preparation in polity to find out which are those fundamental rights which have horizontal application and no vertical application, or only vertical application and no horizontal application. I'll give you a hint in this, that Article 19 and 21, which had only vertical application, has now also horizontal application. ठीक है, तो ये एक चीज अब ध्यान रखिए, यहाँ पे एक क्वेश्चन आप और एक्सपेक्ट कर सकते हो. But again, as I said, that this topic makes more sense for the mains examination. It's the same topic which UPSC asks, whether in prelims or in mains. It's the nature. of the topic that alters. ठीक है? Is this topic clear to everybody? Shall we move forward? तो जलीकट्टू clear हुआ? ये भी clear हुआ? Very good. Let's move forward. The next one is Supreme Court's verdict on same-sex marriage. Now, you know, same-sex marriage means homosexual civil unions. Now, homosexuality has been decriminalized in India following Supreme Court's ruling with respect to Section 377. So, homosexuality is now decriminalized in India, but same-sex marriages has not been legalized yet. So, these are two different things. First, homosexuality, and second is same-sex marriage. Homosexuality has been, like discrimination against homosexuality has been abolished, or homosexuality has been decriminalized in India. So, if there are consenting adults now who engage in the act of homosexuality, there cannot be a criminal proceeding established against them following the Supreme Court's judgment. But there is still no recognition of homosexual couples in nuptial bonds or through marriages, or marriage is still not allowed for homosexual couples. Okay. Now, here we have to understand two important things. First is the angle of law, and the second is the angle of societal ethics. Okay. When it comes to angle of law, when we talk about non-discrimination, you know that there is an article in the Indian Constitution called Article 15, which says that the state shall not discriminate only on the grounds of religion, race, caste, sex, place of birth, or any of them. Now, sex here is not only your biological identity, but Supreme Court has taken a view that sex here is also your sexual orientation. Do you understand that? Now, there is something called, I hope you are aware about LGBTQIA+. I hope you are aware about that, right? So, let me just highlight this to you. Throughout the world, there is now a movement. This movement is sometimes known as the LGBTQIA+ movement, or the gay rights movement, or sometimes the rainbow revolution. Okay, there are several names that are given to this movement. Now, who are these people? Let's try to understand or define them properly so that we can understand what the Supreme Court has said. Lesbians are women who are sexually attracted to women. Gays are men who are sexually attracted to men. Bisexuals are persons who are sexually attracted to both men and women. Transgenders are those who are yet to ascertain their gender identity. Keep this in mind. Transgenders are those who are yet to ascertain their gender identity. It means they feel that they are trapped in the wrong gender, and they are the people who will use pronouns when they would identify themselves in public discourse. Queer are people who have yet not identified what they are. They are lesbians, gays, bisexual, or straight. What are they? They have not yet identified that. Intersex is a biological position. Intersex means you have both the sexual organs of the male as well as the female. This could be at birth, this could also be at the time of puberty. Asexual are those who have no sexual orientation. There is no sexual orientation. And plus means all those other people who cannot be defined through these definitions. Do you understand that? So, this LGBTQIA+ movement, it has gained momentum now throughout the world. Since the dawn of human history, if we see that people with, say, not the orthodox or heterodox sexual orientation have been there in every society. but several societies have made laws and have curbed these actions. In decriminalization of section 377, Supreme Court has only ascertained the sexual rights of people who are also a type of sexual minority. Do you understand that? And it has also protected their sexual orientations. Now, the point is that although this is decriminalized, homosexuality is decriminalized, marriage is not allowed still with respect to this. So, there was a kind of say appeal before the Supreme Court to grant marriage permissions also. There the Supreme Court has said, and this is our news, there the Supreme Court has said that although or notwithstanding the decriminalization of homosexuality, same-sex marriages cannot be allowed as of now. Do you understand that? Now, there are two angles to this. First angle is the prevalent societal ethics and the legal challenges to it. Do you get that? Because now marriages are generally conducted under personal laws, and those who do not fall under any personal law, especially interfaith marriages, you will say there is the Special Marriage Act. But how to regularize or where to place these marriages? Because traditional religious marriage acts, they do not create the window for homosexuality. So, they cannot be accommodated under those laws. First problem, legal challenge samajhne ki koshish karo. Second is the societal challenge. Even if these marriages are allowed, the society is still not ready to accept them or integrate them. Now, whether that's a good thing or a bad thing, we will not go into that debate today, because that will take us to mains territory, right? We are only here to understand what the court has said from the prelims perspective. Secondly, the Supreme Court has said that making marriage laws or regulating civil unions or even adoption, for example, these should be done by the parliament, because it is reflection of societal ethics which is executed through common law or which is executed through popular law, and parliament is the temple where people's will should be channelized to give it a shape in the form of a law. In other words, that the court will not interfere in this matter. Court can only determine a particular existing law's status or section status in the light of the ethos of the constitution and constitutional morality, or the provisions or the basic structure of the constitution. In simple words, that the court will only check the constitutional validity or the unconstitutional status of a particular law or section. Court will not suggest policy. Do you understand that? The government of India has taken a stance that still the society is not ready for that kind of a transition, although the government has acknowledged that it is ready to form a high-powered committee under the chairmanship of a man not lesser than the cabinet secretary himself, and it will give recommendations on the basis of which there could be some substantial movement in this direction. Nearly 133 countries have decriminalized homosexuality, but some 38 odd of them have only legalized same-sex marriage. Because to decriminalize homosexuality is relatively easy, because it is something which is between consenting adults and in private space, whereas marriage is a social affair. Do you understand that? And to ascertain that in a society which is still driven by ethos and culture and cultural traits, and which is not yet ready to accept homosexuality, it will be a challenge. Do you understand that? And if we accommodate such kind of marriages under the, say, the religious marriage laws or the personal marriage laws, be it for the Hindus or the Muslims or the Christians or something like that, then there could be challenges, because these laws might not create that window for the accommodation of these kind of marriages. Do you understand that? So, this is the news. Did you understand it? Let's take a look at it now. The Supreme Court of India, in a significant verdict regarding the legal recognition of same-sex marriages, unanimously, so you see there is no difference of opinion among judges, ruled against legalizing same-sex marriages in the country. A 5-judge constitution bench led by the earlier Chief Justice of India, D.Y. Chandrachud, delivered the verdict. The court determined that the authority to grant such recognition resides with the Parliament, not with the judiciary. Now, government's stand regarding same-sex marriages, the government maintained that Supreme Court in its 2018 judgment in Navtej Singh Johar versus Union of India had only decriminalized homosexuality but had not granted legitimacy to it. The government has argued that marriage depends on customs, rituals, practices, cultural ethos and societal values. The country's marriage laws as established by Parliament recognize only heterosexual unions. Granting legal recognition to same-sex marriages would conflict with personal laws currently in place. The Special Marriage Act of 1954 offers a civil marriage option for couples who do not fall under personal laws. The government asserted that any changes to this framework should be made by the legislature, not the Supreme Court. What are the key highlights of the verdict? No fundamental right to marry. Now, this is important from the prelims perspective. Do you understand that? There is no fundamental right to marry. Nobody can claim that I have a fundamental right to marry. Okay. The court stated that Constitution guarantees does not explicitly recognize a fundamental right to marry, especially concerning same-sex couples. It is also with respect to heterosexual couples, but especially same-sex couples also. Role of legislature emphasizing the principle of separation of powers. Now, this is a clear affirmation of the existence of separation of powers, because the court should not interfere in policy matters. Court should only check the constitutional validity, or it should check the, or it should test the laws. It should test the policies. It cannot make policies. It cannot make the laws. Then it would be gross violation of separation of powers. Civil unions and adoption rights. Civil unions are mostly like, these are marriages which are recognized by the society. And adoption rights. In 3-2 majority decision, the court declined to recognize civil unions for same-sex marriages and ruled against granting adoption rights to such couples. Protection against discrimination. The court acknowledged the discrimination faced by the LGBTQIA plus community and have also directed the central government to take steps so that these people do not have to face a lot of discrimination or unnecessary discrimination. What is the conclusion? Same-sex marriage is legal in 38 countries worldwide, encompassing approximately 1.5 billion people, or about 20% of the global population. It is worth noting that in 133 countries, homosexuality has been decriminalized. Do you understand that? तो इसमें बस एक ही चीज आ सकती है, which is with respect to the highlights of the verdict. Do you understand that? And also, there could be a statement like homosexuality or same-sex marriages is decriminalized and legalized in India. Do you understand that? Same homosexuality is decriminalized and same-sex marriages are legalized in India. The first part is true. The second part is not true. Okay. Clear hua? Is this topic clear to everybody? Okay. Let's move forward. BCI's approval to foreign lawyers and law firm, which is nothing but the Bar Council of India. अभी इससे पहले क्या होता था? That foreign lawyers and law firms, they could advise their clients in India, but they could not practice as such in India. But recently, the Bar Council of India has modified its 2022 rules, and through this rule, it has given permission to foreign lawyers and foreign law firms to practice law in India, but with certain conditions. Do you understand that? And in these conditions, the Bar Council of India has also protected the interests of the domestic lawyers and domestic law firms. This move is remarkable because it will not only attract FDI with respect to legal occupation in India or legal services in India, but it will also make India a hub of international arbitration. especially with respect to intellectual property, mergers, joint ventures, etc. So commercial activities or commercial activities that have a bearing into law or litigation around commercial activities will pick pace in India, and that will also bring the best practices of the world in India. Do you understand that? But the BCI or the Bar Council of India, which is nothing but a regulatory body that regulates the profession of advocates, or which regulates the profession of law and legal education in India. Okay, so the Bar Council of India, like you have the Medical Council of India, so this is the Bar Council of India. It functions on a principle called the reciprocity principle. Now this is important for the preliminary examination. Reciprocity principle means कि इंडिया में हम उन्हीं फॉरेन लॉयर्स और लॉ फर्म्स को जगह देंगे जो हमारे लॉयर्स और लॉ फर्म्स को उनकी कंट्री में जगह देंगे. Do you understand that? So it's a kind of reciprocity. It means you help us establishing our law firms in your country and allow our lawyers to practice there. We will reciprocate. Do you get it? There is also something called fly in and fly out with respect to this decision. Fly in and fly out मतलब वहाँ पे आपको कोई requirement नहीं चाहिए, but कुछ conditions है कि आप जल्दी से आकर country में कुछ legal advice देकर जा भी सकते हो वापस. ठीक है? Again, everything functions on the basis of the reciprocity principle. Let's take a look at this. The Bar Council of India has introduced the Bar Council of India rules for registration and regulation of foreign lawyers and foreign law firms in India 2022, permitting foreign lawyers and law firms to practice in India under specific conditions. Now, in preliminary examination, what is important now? The Bar Council of India. The Bar Council of India is a statutory body established under the Advocates Act 1961, responsible for regulating legal profession and legal education in India. Key functions of BCI: regulation of legal education, prescribes standards for law colleges and universities. Regulation of legal profession, sets rules of professional conduct for lawyers. Granting licenses, conducts the All India Bar Examination for law graduates to practice in courts. जिससे लाइसेंस मिलता है एडवोकेट्स को. जब लॉयर को लाइसेंस मिल जाए तो वो एडवोकेट, ठीक है, उससे पहले वो सिर्फ लॉयर. अगर आपने BLLB किया है तो आप क्या होंगे? लॉयर. लेकिन जिस दिन आप बार काउंसिल ऑफ इंडिया का लाइसेंस ले लेंगे, यू विल बिकम अ एडवोकेट. डू यू अंडरस्टैंड दैट? वकील और अधिवक्ता का जो फर्क है. ठीक है. Disciplinary actions, has the power to take disciplinary action against advocates for misconduct. Recognition of foreign lawyers, regulates the entry and practice of foreign law firms in India. Composition of the Bar Council of India: chairman and vice chairman elected from amongst its members. Members from the state bar councils represent different states. Attorney General of India and Solicitor General of India ex officio members of the Bar Council of India. ठीक है. और ऐसे ही स्टेटमेंट्स आते हैं जहां पे लगता है कि अटॉर्नी जनरल तो होगा, सॉलिसिटर नहीं होगा. ऐसे कंफ्यूजन होता है ना. तो इसलिए इन चीज़ों को ध्यान में रखो. ये जो भी इंपॉर्टेंट चीज़ें हैं प्री के लिए, उसको मैंने बॉक्स में कर दिया है. ठीक है ना. तो वो ज़्यादा अच्छे से पढ़ना. अगर समझ लो ये पूरा पढ़ने का टाइम नहीं, तो बॉक्स में जो जो है वो आइटम ज़रूर आप पढ़ लेना. BCI acts as the apex regulatory body for legal professionals, ensuring that the legal system in India functions smoothly and ethically. According to the Advocates Act 1961, advocates enrolled with the Bar Council alone are entitled to practice law in India. All others, such as litigant, can appear only with the permission of the court, authority or person before whom the proceedings are pending. अब देखो इसका मतलब क्या है नए BCI rules का मतलब. The notification allows foreign lawyers and law firms to register with the BCI to practice in India if they are entitled to practice law in their home country. पहले आप अपनी कंट्री में तो लॉयर होने चाहिए, तभी आप यहाँ पर लॉ प्रैक्टिस कर सकते हो. स्कोप ऑफ प्रैक्टिस: परमिटेड एरियाज एंड प्रोहिबिटेड एरियाज. ये हाईलाइट कर दिया गया. परमिटेड एरियाज: advising clients on foreign law, handling international legal issues, participating in international arbitration cases, mostly economic related cases. Prohibited areas: practice Indian domestic law, नहीं कर सकते. Appear before Indian courts, tribunals or other statutory or regulatory authorities. This is also prohibited. Reciprocity principle, as I highlighted, the BCI's decision is based on reciprocity principle, allowing foreign entities to practice in India only if their home countries extend similar privileges to Indian lawyers and law firms. Fly in and fly out provision, इसका मतलब क्या है देखो. foreign lawyers can offer legal service on a temporary fly-in and fly-out basis without registration, provided these conditions are met. The visit does not exceed 60 days in any 12-month period. The advice pertains to foreign law or international legal issues only, and not to Indian domestic law. They do not maintain a permanent office in India for such practices. So here you may have, it's like, are you aware about visa on arrival? वैसे practice on arrival ऐसा कुछ समझ सकते हो, ठीक है, fly in and fly out, but you have to maintain these conditions. अगर आपने इस conditions को break किया, then there will be action against you, आपको blacklist भी किया जा सकता है, and monetary penalties can also be imposed over you. Conclusion is obviously foreign lawyers and law firms, they will get an opportunity to operate in India. It will attract FDI with respect to legal services in India, and also it will make India an hub of international arbitration. Further, it will also bring the best legal practices or the state of the art legal practices in India, by which the Indian lawyers will also benefit. Take it. Is this thing clear? Let's move forward then. Agnipath scheme, legal challenge and promissory estoppel. Now, I hope all of you are aware about this Agnipath scheme. Now, Agnipath scheme is actually a scheme which was launched by the government of India in 2022, and the idea was to go for 4-year period recruitment, okay, of youth in the Indian Armed Forces, Navy, Air Force and the Indian Army. For 4 years they will hold their office, and the age bracket which was chosen was 17 to 21, but पहले साल के लिए उसको relax करके 23 years किया गया था, but then it was brought down. The whole idea of this scheme is twofold. First, to energize the armed forces with the energy of the youth, or to bring down the average age of the army personnel in India. First objective. Second objective is to modernize the armed forces, so that these young people can bring the technical knowledge also and the technical side of military administration as well in their work culture. Now, these people who would serve under the Agnipath scheme will be known as Agniveers. I hope you are aware about it, okay. And it became a matter of controversy. Why? Because the scheme said that once the 4-year period is completed, 75% of the recruits, they will be relieved, and only 25% of them will be reinstated, or they will be commissioned. Do you understand that? That is what the scheme said, that their employment will continue, but 75% will be relieved. So that's first thing. Then the government said that those who would be relieved, they will get a nidhi, or a kind of fund, okay, which will have a certain corpus, and they will also have a insurance cover during the training period or during their service period of 4 years, and in case of death that will amount to say 1 crore. Anyhow, we'll look into those provisions later, but in total try to understand the scheme. So government of India comes up with a scheme. The scheme is known as the Agnipath scheme. Through the Agnipath scheme, the government seeks to recruit youth in the Indian Armed Forces, Army, Navy and Air Force for a short period of 4 years. After the successful completion of the 4 years, 75% of the recruits will be not continued, and only 25% of them will be continued. But once they are relieved, 2 things will be done. One, a Samman Nidhi would be given to them, and there will be also bridge courses which the government will launch, through which they can make transition to other sectors of the economy. Now, this Agniveer or the Agnipath scheme itself was challenged before the Supreme Court of India, and the Supreme Court of India said that this scheme which is launched by the government of India. Okay, the ground of challenge that was the ground before the Supreme Court was that it is breach of the doctrine of promissory estoppel. Now, what is this doctrine? Doctrine of promissory estoppel. It means that a promise has been made, although the promise has not been made in written form, but to whom the promise is made gives the person a kind of understanding that there will be honor of the promise, or the promise would be honored. But if the promise is broken on a later day, that amounts to injustice. So there were people who had qualified the army examinations, navy examinations, or air force exam, armed forces examination under the old system. And when the Agnipath scheme was launched, all of them went to the Supreme Court of India. They said that we have already been recruited, and now there is a sudden shift in government's policy, and that amounts to the breach of the doctrine of promissory estoppel. Now, the Supreme Court, after hearing the government's arguments and the petitioner's positions, Supreme Court declared that the Agnipath scheme is constitutional and valid, because it has been done by keeping national security in mind, and the government is also taking adequate safeguards. So you cannot invoke the doctrine of promissory estoppel on the ground that it was a livelihood question for you, when the larger question, which is around the corner, is the question of security of the nation and modernization of the armed forces. Again, clear establishment of separation of powers, where the Supreme Court said that we will not intervene. We will just see that whether the policy that has been made is constitutionally valid or not. It is constitutionally valid. Also, the government has promised that those who would not be recruited, उनके लिए bridge courses बनाए जाएंगे, so that they may have a transition, और उनको एक सम्मान निधि भी दी जाएगी once they are discharged from their duties. Got it? So let's take a look at this. The Supreme Court has recently rejected petitions challenging the Delhi High Court's decision that upheld the Agnipath scheme for recruitment into the armed forces. Previously, the Delhi High Court has already upheld this, and there were petitions which challenged the Delhi High Court's judgment, and Supreme Court has rejected those band of petitions. What is the Agnipath scheme? The Agnipath scheme is a short-term recruitment program introduced by the government of India in 2022 to enlist young individuals into the Indian Armed Forces, Army, Navy, Air Force for a period of 4 years. It is only for the recruitment of personnel below officers. It means जो commissioned officers हैं, उनके नीचे के rank में ही ये सारे होंगे. Commissioned officers, they generally get their order directly from the Honorable President of India and work under certain commissions. That's why they are known as commissioned officers. Okay, अभी के लिए इतना काफी होगा आपको जानना. Features of the Agnipath scheme: short-term service, recruitment of 4 years in the Army, Navy, or Air Force. Agniveers, the recruits are known by that name, serve for a fixed duration and are not guaranteed permanent positions. Eligibility 17.5 to 21 years, up to 23 years for 2022 recruitment as a one-time relaxation, but अब इसको वापस 21 years कर दिया गया है. Educational qualification, matriculation and higher secondary education depending upon the position that you are applying. Salary and benefits: salary would be 30,000 to 40,000 with additional benefits such as allowances, insurance and health care. Post service: after 4 years service, 75% of Agniveers are discharged and the remaining 25% may be absorbed into the regular armed forces based on their performance and vacancies. The discharged Agniveers will receive a severance package, which is like a Samman Nidhi of 11.71 lakh depending on their years of service. If they complete 4 years, they will get that amount. The government will help rehabilitate soldiers who leave the services after 4 years. They will be provided skill certificates and bridge courses so that they can make the transition. Insurance and cover: Agniveers will also get a 48 lakh life insurance cover for the 4 years. In case of death, the payout will be over 1 crore, including pay for the unserved tenure as well. मतलब वो 48 lakh भी तो मिलेगा, और अगर death हो जाती है तो 1 crore. और उससे ऊपर भी जो भी रिमेनिंग पीरियड होगा उसकी जो सैलरी होगी वो भी दी जाएगी. Training and skill development. Agniveers will undergo rigorous training and skill development which helps them in career transition after their service ends. Under the new scheme, around 45,000 to 50,000 soldiers will be recruited annually. However, after 4 years, only 25% of the batch will be recruited back into their respective services for a period of 15 years. And this clause, that it would be a temporary kind of arrangement, not a permanent kind of arrangement, was the point of argument. And especially you see that those who were challenging the decision of the Delhi High Court or the scheme, they were pointing towards this thing, that how this can be done. And those who had already been recruited, they were saying that it's the breach of doctrine of promissory estoppel. Objectives of the Agnipath scheme: modernizing of the armed forces, cost effectiveness because reduced long-term salary and pensions, which is a big burden on the public exchequer and may help in fighting fiscal deficit in the long run. Youth empowerment, providing young people with opportunity to serve and gain experience in structured environment. Like, you might be aware about this, that in United States, you'll find there are so many people who have served in the Navy, and then they have come back and they have gone into different vocations or different avocations, right? Like, it is a customary practice in the West that some people may serve in the Navy, in the Army for short periods, and then they come back. And these kind of people who have served in the defense forces, they are given primacy in recruitment, right? Have you also seen that in the UPSC also it will ask, are you an ex-serviceman? So these kind of people are given a kind of, you can say, priority. This is the doctrine of promissory estoppel. The doctrine of promissory estoppel prevents a party, usually the government, from going back on a promise. If a clear promise was made, even if not in a formal contract, the other party relied on the promise and acted upon it. Not enforcing the promise would cause injustice. That is the doctrine of promissory estoppel. तो यहाँ पे जो question बन सकता है prelims के लिए वो क्या बन सकता है? Doctrine of promissory estoppel. Do you understand that? Which was in news recently. It relates to Agnipath and doctrine of promissory estoppel. Breach of prior recruitment promise. Candidates argued that since they had cleared earlier recruitment exams under the old system, they had a legitimate expectation of being recruited as per the previous policy. Sudden policy change. Since they had invested time and effort in clearing previous recruitment phases, they contended that abruptly cancelling their selection violated promissory estoppel. Legal precedent. Supreme Court has upheld the doctrine of promissory estoppel in multiple cases before. So they were also hopeful that Supreme Court will uphold it, Supreme Court's ruling. In 2023, the Delhi High Court upheld the Agnipath scheme, ruling that the recruitment processes are subject to government policies and promissory estoppel does not apply to policy decisions. The Supreme Court later dismissed appeals against this ruling, stating that the government retains the right to alter recruitment policies for administrative efficiency. Okay, so while the doctrine of promissory estoppel is a powerful legal tool, courts have consistently held that it cannot be applied against government in matters of policy changes unless there is a clear case of mala-fide intent. Okay, तो ये चीज आपको ध्यान में रखना है. So are you clear with this one? Doctrine of promissory estoppel. So is the Agnipath scheme now valid? Yes, because the Supreme Court has validated it. Question बस यही हो सकता है इसमें कि there could be a political question, not a legal or a constitutional question with respect to Agnipath, and we are not interested in political questions. That is beyond the ken of the demand of this examination, so let's not go into that arena. Let's move to the next one. Loudspeakers and essential religious practices. Now, the Bombay High Court in a January 2025 decision recently has said that loudspeakers do not form a part of essential religious practice of any religion. Do you understand that? It means that loudspeakers cannot be used in an unrestricted fashion. Loudspeakers cause noise pollution, and noise pollution is a part of air pollution. Are you aware about this fact? Noise pollution is a part of air pollution. Do you understand that? Overall air pollution. So there is something called essential religious practices. Now, what are essential religious practices? Essential religious practices are those practices without which you will not be able to fulfill your duties as a religious person. These are essential religious practices. Do you understand that? Like, say for example, some of the rituals that are necessary, some of the observances that are necessary with respect to a particular religion. If you do not follow these essential practices, you will not be considered as a person of that religion. Now, who decides that whether a practice is an essential religious practice or not? It's the judiciary, which decides whether the practice is an essential religious practice or not, but not in void. The judiciary decides it on the basis of the interpretation of the scriptures of that religion and the historical precedents set in that religion. Do you understand that? Like, say for example, for a particular religion, offering a particular or say observing a particular fast on a particular day could be an essential religious practice. So whether it is actually essential or not is ascertained by the judiciary after interpreting the scriptures and after looking into the historical precedents of practices with respect to that practice. Take it. The point here is that the Bombay High Court has said that loudspeakers or the use of loudspeakers does not amount to essential religious practice in any religion. Do you understand that? And therefore, in the larger public interest, because Article 25 Clause 1, which gives all the people in India what? The freedom to practice, profess and propagate their religion, also the freedom of conscience. So this practice only includes essential religious practices. It does not include all the practices as fundamental right. Do you understand that? That's first thing that you have to keep in mind. And secondly, is the right guaranteed under Article 25 Clause 1 absolute? It can be reasonably restricted on the grounds of public health, morality, decency, etc. So that's why, just imagine if there are hospitals or schools and there is constant use of loudspeakers throughout the day, then you can understand, also during the night, then you can understand it would cause a lot of trouble to patients, students, etc. And that's why the government said, or rather the government believed, that these loudspeakers should be regulated. And the Bombay High Court has upheld this and claimed that the use of loudspeakers does not amount to an essential religious practice. अब अगर क्वेश्चन आएगा तो वो किस पे आएगा? Essential religious practice. ठीक है? Let's take a look at this. The Bombay High Court ruled in January 2025, it means recently, that the use of loudspeaker does not constitute an essential religious practice protected under Article 25 or Article 19 Clause 1 subclause A, which is freedom of speech and expression. It means your freedom of expression, religious expression of the Constitution. What are essential religious practices? The term essential religious practice refers to those practices or rituals that are fundamental to the identity and beliefs of a particular religion. These practices are considered necessary for the proper practice of faith and are protected under the Indian Constitution. They are safeguarded by Article 25, which ensures freedom of religion in India. The judiciary determines whether a practice is essential based on religious tenets and historical significance. Supreme Court's 2016 judgment on loudspeakers in Dr. Mahesh Vijay Bedkar versus Maharashtra, the Supreme Court ruled that the use of loudspeaker is not an essential religious practice and cannot be claimed as a fundamental right under Article 25, which is freedom of religion, and 19 Clause 1 subclause A, which is freedom of speech and expression. Noise pollution is a part of air pollution. Noise is classified as an air pollutant and is regulated under the Air Prevention and Control of Pollution Act 1981. The Act sets a permissible noise limit of 55 decibels during the day and 45 decibels at night in residential areas. अलग-अलग areas में इनका अलग-अलग एक chart है, right? UPSC is not going to ask you the actual numbers, that how much decibels and all of that. Rather, it will address the broader question. By asserting that the use of loudspeaker is not an essential religious practice, the courts have reinforced the primacy of public well-being and right to a peaceful environment. Okay, you tell me one thing. Is the right to a peaceful environment an integral part of your right to life? Right to life means what? Right to life means a dignified life. A dignified life means there should not be any kind of intrusion. अब ये लाउड स्पीकर्स अगर आप देखोगे ये क्यों यूज हो रहे हैं? ये यूज हो रहे हैं mostly because of the competitive politics that goes on in India. Do you understand that? And assertive politics that goes on in India. Like there is a faction which says that will not allow, and there is a faction which says we will do it. So this is the sorry state of affairs. But the vulnerable sections like patients, students, and or say animals also, to some extent, you see, they are not taken into consideration. So if a district magistrate passes an order that loudspeakers are not allowed after this hour of the day, or this is the decibel level that you have to maintain, then such an order will be valid and constitutional. Is this thing clear to everybody? Okay, let's move forward. National anthem protocol. Now, this also relates to an incident that happened in the Tamil Nadu Legislative Assembly. The governor of Tamil Nadu, he decided not to deliver his speech, and he walked out of the Legislative Assembly because before his address, the national anthem was not played. Now, in Tamil Nadu, the practice is that before the delivery of the governor's address, there will be the state anthem which will be played. After the delivery of the governor's address, there will be the national anthem which will be played. This is not only with Tamil Nadu, but some other states have also some certain kind of exceptions. We'll talk about that in a moment. But the argument here is that this is not the first time that the Honorable Governor has decided to walk out from the Legislative Assembly. Even before this, he said that the national anthem should precede the state anthem. And this is his third walkout from the Legislative Assembly. Now, this also brings to open a kind of conflict between the governor on one side and the state government on the other, right? But we will not go into this conflict and the powers of the governor and whether we should have an elected governor, appointed governor, because that will take us into the mains territory. For prelims, what is important is everything related to national anthem. अब national anthem से या तो फिर आपका जो convention है उससे related question आ सकता है, कोई law अगर है उससे related question आ सकता है, या तो फिर history of the national anthem. Got it? The national anthem, when it was sung, when it was, who composed it, and all of it, right? So let's try to take a look at this event. On January 6, 2025, which is again very recent, the Tamil Nadu Governor R.N. Ravi left the Legislative Assembly without delivering his customary address, citing the non-playing of national anthem before his scheduled speech. Protocol for Indian National Anthem. The Indian National Anthem, Jana Gana Mana, holds a prominent place in nation's identity and culture. Its performance and usage are governed by specific protocols which are important for maintaining respect and dignity. Okay, is it our fundamental duty also to respect our national anthem? Yes, it's a fundamental duty. अब देखो, जब आप national anthem गा रहे तो बहुत सारी चीजें आपको ध्यान में रखना पड़ेगा. एक तो आप अपने आप नया लिरिक्स नहीं ऐड कर सकते, जो है वही आपको गाना पड़ेगा. जो डेजिग्नेटेड टाइम है उसी टाइम में गाना पड़ेगा. एक नया सुर नहीं लगा सकते, ठीक है ना. जो है टेम्पो वो भी आपको मेंटेन रखना पड़ेगा. अगर आपने ऐसा कुछ भी किया, आप डांस नहीं कर सकते, कोई भी बॉडी मूवमेंट नहीं होनी चाहिए. इट वुड बी अ डिग्निफाइड साइलेंट पोस्चर. दैट इज हॉलमार्क ऑफ रेस्पेक्ट फॉर द नेशनल एंथम, ठीक है. But if you violate all of that, then you are violating the protocol with respect to national anthem. Now, you must be aware about this as well, that in cinema halls or even before cricket matches, there is now a practice of playing the anthems. Say in cricket matches, obviously there is our anthem and the opposing team's anthem. But in cinema halls, have you seen this? That before the movie starts, there would be national anthem. And whenever the national anthem plays, everybody should stand. The protocol says everybody should stand with respect and dignity, save perhaps those who are specially abled. But they should also show reverence towards the national anthem in other possible ways. Do you understand that? Or respect towards the national anthem in other possible ways. So playing national anthem before the movie starts, whether this is correct or whether this is not, what are the implications of it, what are the challenges in its implementation, these are all matter of the mains examination. ठीक है ना? Preliminary examination में हमें सिर्फ national anthem के protocol को समझना है, उससे ज़्यादा कुछ भी नहीं. Now, previously the general understanding was that everybody should stand before the national anthem, when the national anthem plays before the start of a movie. But then now the popular understanding is that it should be left to the people, that whether they want to stand or they don't want to stand, because respect for the nation comes out of genuine patriotism. It cannot be enforced through law. Do you understand that? That is the popular understanding. चलो देखते हैं इसको. Rules for playing or singing the national anthem. Respectful posture. When the national anthem is played or sung, all individuals present must stand in attention as a mark of respect. Exceptions. Persons with physical disabilities may remain seated, but they must show respect in other ways. No interruption. The anthem should be sung or played in its entirety without any interruptions. Any modification of the anthem, whether in terms of melody or lyrics, is strictly prohibited. मतलब ऐसा नहीं कि आपने कोई remix बना दिया है. Not possible, right? Instrumental performance. Even if you are performing the national anthem with the use of instruments, you should maintain the tempo of the national anthem. You cannot change the tempo of that, and decorum also. Public events. The anthem is often played at the beginning and the end of the official ceremonies, national events, sports events, and film screenings. Guidelines for singing the national anthem. Solo or group performance, whether sung individually or by a group, the anthem must be rendered with proper reverence. The correct tempo must be maintained while singing. Tempo, rhythm should not be broken, right, with respect to the national anthem. Authorized lyrics. The lyrics of the national anthem must be sung as per the version adopted by the Government of India, and no changes in wording or order are allowed. ठीक है. Usage and display. Public display. The national anthem can be displayed at public places, schools, and official buildings. It should be displayed in a proper format. Have you seen on the walls of government schools, sometimes the national song as well as the national anthem would be written, but it should be written with proper format. Films and media. The anthem may be played at the beginning or end of the films or shows, but the context must be respectful, and no commercial use of the national anthem should be made with respect to any movie. ऐसा नहीं है कि national anthem आप दिखा रहे हो और उसी के बीच से हीरो निकल रहा है, नहीं हो सकता, ठीक है? That would be detrimental. Prohibited practices. No commercial use, obviously. No dancing or physical movements, and respectful silence. The national anthem, when was it adopted? Okay, the national anthem is composed by Gurudev Rabindranath Tagore, originally in Bangla, then translated into Hindi, and the entire thing has not been taken as the national anthem, but only a certain section of it, and it was then sung where? In which session of the Indian National Congress? ये तो current affair भी नहीं है. Jana Gana Mana, originally composed in Bangla by Rabindranath Tagore in 1911, was later adopted as India's national anthem. In its Hindi version, it was first sung December 27, 1911 during the Calcutta session of the Indian National Congress. Do you understand that? and disrespecting or showing any form of dishonor to the Indian national anthem may result in legal penalties as outlined in the Prevention of Insults to National Honor Act 1971. Supreme Court's observation related to national anthem in cinemas. As I told that initially it was mandatory, but then later on viewers were required to stand in respect except for those who with disabilities, but later in 2018 modification, the court modified its earlier order, said that it is now optional. Government was given discretion to decide on the matter. The court emphasized that respect for national anthem should come from genuine patriotism, not legal enforcement. Safeguards for protecting the honor of the national anthem. और यहाँ पर ये देख लो, there you can expect some questions for the preliminary examination. First, constitutional duty. Article 51A, subclause A of the fundamental duties mandates every Indian citizen to respect the national anthem along with the constitution, national flag and institution. ये तो constitutional provision हो गया. Legal protection क्या है? The Prevention of Insults to National Honor Act 1971 prescribes up to 3 years of imprisonment, a fine or both for disrespecting the national anthem. Those convicted under this act are barred from contesting elections for 6 years. MHA guidelines, the Ministry of Home Affairs mandates that the full national anthem at official events such as investitures, parades, national salutes and formal functions involving the president, governor and armed forces ceremonies. कहीं पे भी अगर governor आ गए या president आ गए या Supreme Court के कोई judge आ गए, High Court के judge आ गए, तो उस convention में national anthem से ही वो शुरू. ठीक है, this is the protocol. Protocol for playing the national anthem. President's address in the parliament. The national anthem is played when the president arrives at the dais and again when they exit after delivering the address. In Indian parliament, you would see as the honorable president walks up to the dais, the national anthem is first played, then delivers the address. Once the address is finished, again the national anthem is played, and that's how the presidential address is taken as done. Governor's address in state legislature. Different states follow different traditions with respect to national anthem. और यहीं पर जो है थोड़ी controversy create हो गई. जैसे देखो, नागालैंड national anthem was first played in the assembly in 2021 after decades of not being included. Tripura introduced the national anthem in its assembly in 2018, and in Tamil Nadu it's the state anthem which is played before the governor's address, and at the end the national anthem is played. Do you get that? So there could be a statement that in all legislative assemblies the national anthem is played before the governor's address. It is not true. Do you get that? So keep this in mind. Tamil Nadu is an exception to that. These protocols highlight the ceremonial significance of national anthem in the official functions across the country. So do you understand this with respect to national anthem? इसमें कुछ आएगा तो ये वाला section है, safeguards, जो भी laws related हैं, and then what is the protocol with respect to national anthem, और या तो फिर ये आ सकता है, here I have not highlighted it in much detail because this is part of your history, right? That where the national anthem was first sung, who composed the national anthem and all of that. The national song was composed by, and later on it was integrated in his novel Anand Mat. Okay. Who sung it for the first time? Vande Matram. Who sung it for the first time? Go on. Go on. Netaji. Bhikaji Kama. Okay, this is homework for you. Hint is in front of you. चलो ठीक है, देख ले, घर जाके तो पता लग जाएगा. Okay, let's look at this Supreme Court and special leave petitions. Now, you know, cases can come to the Supreme Court by way of appeals, right? And high courts, what they do is that they give certificates. On the basis of those certificates, appeals can be filed against the High Court pronouncement in the Supreme Court. And obviously, in some cases, appeal is by default, like say for example, in death penalties and some sort of those things. So there is another provision in the Constitution by Article 136, which is known as appeal by special leave. Now, what is this? By this, the Supreme Court can drag from any court or tribunal any case before it for its adjudication. Do you understand that? This is known as appeal by special leave. but it excludes military tribunals. From military tribunals, the Supreme Court cannot drag cases before it. Why the Supreme Court has prioritized the special leave petitions? Because nearly 82,000 cases are pending, or in fact more than 82,000 cases are pending in the courts, and that's why the Chief Justice of India has made a strategy with respect to prioritizing the special leave petitions. So this is the Supreme Court's observation. Context समझ में आ गया? Let's try to understand. In December 2024, which is again very recent, the Supreme Court of India introduced a plan to give priority to special leave petitions in an effort to tackle the huge backlog of cases. The court has over 82,000 pending cases. What is special leave petition? A special leave petition is a legal provision under Article 136 of the Constitution which allows the Supreme Court of India to hear appeals against judgments or orders passed by any lower court or tribunal in the country excluding military tribunal. So ये याद रखना, ठीक है? यहाँ पे it is excluding military tribunal. Key features of the SLP: filed against any judgment. SLP can be filed against decisions of high courts, tribunals and other judicial bodies, not an automatic right. This is again something that you have to keep in mind. Unlike the other appeals, the Supreme Court may or may not accept an SLP for hearing. It is granted only if the case involves a significant legal question that has a larger public significance, okay, or larger public impact. Time limit जो है within, against a high court judgment within 90 days from the date of judgment, against a refusal of a high court to grant a certificate of appeal within 60 days. Do you understand that? Applicable in both civil and criminal cases. SLP can be filed in both civil and criminal matters if they involve important legal principles. Purpose of SLP: provides individuals and entities with a final opportunity to seek justice at the Supreme Court. The idea of special leave originates from the Government of India Act 1935, which had acknowledged the authority to permit special leave appeals. तो आप समझ सकते हैं कि pre का पूरा question तो इसी box से बन जाएगा. So you get that? So that's why I have kept these things which are more important for the preliminary examination into these boxes. So please go through these boxes definitely, without doubt. So by streamlining the process of SLP, the court is trying to do two things. First, it is giving an opportunity to the people to have a final appeal before the Supreme Court, and secondly, it is clearing the backlog of the pending cases. Okay? So do you understand the special leave petition, the SLP? Let's now move to the next one. Supreme Court's verdict on subclassification of SCs and STs. Now, yes, go on. Sorry, go one more time there. Yes, yes, it's a petition. It's a petition. Now, look here. Are you aware about the concept of creamy layer? The concept of creamy layer is applicable with respect to the OBCs. Okay, and also when you look at economically weaker section kind of reservation, it is actually based on the principle of creamy layer. Okay. But the concept of creamy layer as such, although the word has not been used, was not applicable with respect to SCs and STs, okay, or the scheduled castes and the scheduled tribe. The Supreme Court has taken a view where it said that the subclassification is necessary even among the scheduled castes and scheduled tribes, because the benefits of reservation is not going to each and every section among the scheduled castes and the scheduled tribes. Do you understand that? So this is something which the judiciary has reiterated every now and then, that we must target the reservations properly. Otherwise, reservation would become a political tool. Do you understand that? And there will be, like you can say, there will be movements, political movements, a particular social group will seek reservation and it would be granted depending upon how much is their weightage in changing the narrative of the political election output. Do you understand that? So based on all these factors, you see that this is done. In fact, Telangana has already started doing the sub-classification. Anyhow, Let's take a look at this. On August 1, 2024, the Supreme Court of India delivered a landmark judgment permitting the subclassification of scheduled caste and scheduled tribe for reservation purposes, overturning of the previous stance. In a 6-1 majority decision rendered by a 7-judge constitution bench led by Chief Justice of India at the time also D.Y. Chandrachud, overruled the 2004 verdict in E.V. Chinnaiya versus State of Andhra Pradesh, which had prohibited such sub-classifications. But now the sub-classifications are allowed. Do you understand that? Constitutional validity of sub-classification. The court held that sub-classification within SC and ST categories is constitutionally permissible under Article 14, which guarantees the right to equality. Now, if you look at Article 14, you find 2 sections of it, right? Equality before the law and equal protection of the law. Equal protection of the law means likes will be treated alike. Therefore, under Article 14, what is prohibited is class legislation. But what is not prohibited is classification for the purposes of legislation. So, this subcategorization is actually making classifications for the purposes of legislation. Do you understand that? And therefore, it is in tune with Article 14. This is what the Supreme Court has said. But the Supreme Court has said that there should be empirical basis for subclassification. It should not be done on the basis of subjective satisfaction of any social group or the subjective satisfaction of any political movement, party or political unit. The judgment emphasized that the subclassification must be grounded in empirical data and historical evidence relating to social and educational backwardness among different communities within the SC and ST categories. Judicial oversight. The court clarified that the states have the authority to implement the subclassification, but it would be subject to judicial review. In fact, judicial review to aap hata bhi nahi sakte. It's a part of basic structure. Limitation on reservation quotas. The ruling explicitly stated that allocating 100% reservation to any subclass within the SC or ST is prohibited. ठीक है, मतलब आपको सबको देना पड़ेगा, but on the basis of the relative backwardness that should be supported on the basis of empirical data. It cannot be on the basis of subjective satisfaction. Application of creamy layer. The Supreme Court had ruled the creamy layer principle, which was earlier applicable to only other backward classes, as established in the Indra Shawni case, which is the Mandal Commission case. Okay, should now also be extended to scheduled castes and scheduled tribe. The court stated that reservation has to be limited only to the first generation. Okay, so the court says that if a generation has taken the benefits of reservation, then it should pass the benefits to brethren within the community, so that all the families can make the actual transition from poverty, backwardness, etc. into mainstream society. Otherwise, what is happening is that within the communities, there are pockets of prosperity, or rather there are islands of prosperity, and there is sea of despair all around. Got it? That there are a lot of people who are still backward with no means of livelihood, no education, no health benefits, but they are technically under the reserve category. And this is one of the major reasons why you would see that many reserved seats remain empty. They are never filled. Now, there is always pressure on the government to fill those seats, but the government has failed recursively to fill those seats because the applicants are not enough. Just imagine, जो कभी स्कूल नहीं गया, जो कभी बेसिक हेल्थ केयर फैसिलिटीज नहीं मिली, जिसको कभी कोई मीन्स ऑफ लाइवलीहुड नहीं, लिखना नहीं आता, पढ़ना नहीं आता, and is just moving in and around, like life is very troublesome, embedded in poverty, hunger, malnourishment. अब आप बोल रहे हो कि आपके लिए हम सीट रिजर्व करके रखे IIT में, समझ रहे हो? It creates a logical क्या बोलना चाहिए, जोक, एक लॉजिकल जोक है कि अगर आप ऐसा करते हो. So for that, what is important is grassroots level empowerment. Even Dr. Ambedkar, when he was ruling down the reservation policy, he said that he does not want it as a permanent affair. Rather, he wants it as a developmental tool which can actually help in making the transition of the educationally and the socially backward people into the mainstream society. but thanks to the politics that has happened with respect to reservation, both anti-reservation and pro-reservation, that the actual beneficiaries जिनके लिए सोचा गया था, they are long lost. So that's why Supreme Court's judgment in this regard will make the states more vigilant with respect to their implementation of policy related to the reservation. Do you understand it now? So that's the case. CBI exempted from state consent for central employees. आपको पता है Central Bureau of Investigation. Now it derives its investigating powers from the Delhi Police Act. Okay. Now the Central Bureau of Investigation can investigate the central employees on the charges of corruption and all those kind of things. But if the central employees were posted in the state government, पहले state government का consent लेना पड़ता central employees को probe करने. जैसे कि समझ लो प्रिवेंशन ऑफ करप्शन एक्ट के अंदर आप किसी को प्रोब कर रहे, तो अगर वो समझ लो किसी स्टेट में एम्प्लॉय, कोई समझ लो स्टेट कार्डर का कोई ऑफिसर है, ऐसे समझ लो, है तो सेंट्रल एम्प्लॉय बट है स्टेट कार्डर में, तो पहले उस स्टेट का परमिशन लेना पड़ता है. एंड समटाइम्स यू नो दैट दिस काइंड ऑफ करप्शन केसेस हैव political and bureaucracy nexus. Got it? And that's why now CBI can directly do it without getting the state's permission. That's a welcome move with respect to the say clean governance in India. So देखो ये case है क्या? Again a very recent thing. Significant ruling on January 3rd, 2025, the Supreme Court of India determined that the Central Bureau of Investigation does not require a state's consent to register a first information report against central government employees under central laws such as Prevention of Corruption Act 1988, even if these employees are stationed within that state's territory. ठीक है, तो अब जैसे ये डिसीजन आया तो दो चीजें इंपॉर्टेंट हो गई. क्या है वो? CBI और FIR. You understand that? कि FIR को भी आपको समझना पड़ेगा कि ये होता क्या है. But anyhow, we'll talk about that later. What is CBI? The Central Bureau of Investigation is India's premier investigating agency responsible for handling high-profile cases related to corruption, economic crimes, special crimes, and national security matters. It operates under the Ministry of Personnel, Public Grievances, and Pensions. याद रखना, ठीक है? कई बार ये क्वेश्चन आता है, CBI functions under which of the ministries? Simple question. And functions as the main agency for investigating cases of national and international importance. It derives its investigative powers from the Delhi Special Police Establishment Act 1946. याद रखना. It is under the Ministry of Personnel, Public Grievances and Pensions, but it derives its investigating powers from the Delhi Special Police Establishment Act 1946. Key functions of the CBI: anti-corruption cases, investigates corruption cases involving central government employees and public officials. Economic offences, handles financial frauds, bank scams and white collar crimes. Special crimes, looks into cases of murder, kidnapping, terrorism and cyber crimes. Interstate and international cases, coordinates with Interpol and other international agencies to probe cross-border crimes. Judicial orders and state requests, takes up cases referred to by state governments or directed by the courts, that the case should be handled by CBI. CBI's jurisdiction and consent. Jurisdiction: CBI primarily investigates cases involving central government employees and public sector undertakings. State consent: while CBI requires state government consent to investigate cases within a state, it does not need consent when probing central government employees. You understand that? अगर स्टेट गवर्नमेंट का कर रहे हो तो आपको स्टेट का कंसेंट अभी भी चाहिए, लेकिन सेंट्रल गवर्नमेंट का अगर कर रहे हो तो आपको नहीं चाहिए स्टेट का कोई भी consent. Supervision over the CBI: the Central Vigilance Commission oversees the CBI's supervision in investigating offences under the Prevention of Corruption Act 1988. In other matters, it lies with Department of Personnel and Training (DOPT) in the Ministry of Personnel, Pensions and Grievances of the Government of India. मतलब आप समझिए कितना कुछ fodder निकल गया for the preliminary examination, the fact-based things, right? Appointment of the CBI director: under the Lokpal Act 2014, a committee comprising of Prime Minister, Leader of Opposition and Chief Justice of India, or in his absence a senior most judge of the Supreme Court, recommends the appointment. The CBI director holds his office for 2 years but can be extended up to 5 years based on his performance. समझ में आ गया? CBI से related again in the box. Okay, so go through this very important. Requirement of state consent for CBI. The Central Bureau of Investigation derives its power, ये तो आपने देख ही लिया, This requirement arises because police in a state is a state subject under entry 2 of list 2, which is the state list under the 7th schedule of the Indian Constitution. But अब ये नहीं चाहिए, ठीक है. Types of consent given by the state, general consent and case specific consent. ऐसे समझा देता हूँ मैं आपको. जनरल कंसेंट मतलब उसने स्टेट ने बोल रखा है कि आप जब चाहे आइए, जो करना है करिए, जिसको इन्वेस्टिगेट करना है करिए, करते. दैट इज जनरल कंसेंट. कुछ स्टेट्स ने जनरल कंसेंट को विड्रॉ कर लिया और वो ये कहते हैं कि आप आएंगे तो आपको हमसे कंसेंट लेना पड़ेगा हर केस टू केस बेसिस. और यहाँ पे हो रहा था प्रॉब्लम. यू अंडरस्टैंड दैट? बिकॉज सीबीआई वांटेड टू इन्वेस्टिगेट the central officers, mostly the IAS, IPS officers, mostly they wanted to investigate, but they were hiding under the garb of the state government. और वो कह रहे थे कि स्टेट गवर्नमेंट से परमिशन नहीं है, तो आप कैसे आप हमको प्रूव कर सकते हो. सो सुप्रीम कोर्ट हैज सेड कि नहीं चाहिए परमिशन, आप कर सकते हो, क्योंकि सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन और सेंट्रल एम्प्लॉयज को नहीं कर सकते इन्वेस्टिगेट, तो क्यों है ये? यू गेट दैट? सो दैट इज द आर्ग्यूमेंट ऑफ द सुप्रीम कोर्ट दैट यू कैन do it now. So that's the position now. The Supreme Court's recent ruling seeks to strike a balance by allowing investigations of central employees while maintaining state autonomy for other cases. When it comes to state employees, state have the autonomy yet, but when it comes to central employees, the state cannot stand in between anymore. Promotion, not a fundamental right. This is also like right to marriage, not a fundamental right. Promotion also not a fundamental right, the Supreme Court has said. Now, you know that Article 16 of the Indian Constitution gives what? Gives the assurance that there will be non-discrimination in matters of public employment. That is with respect to recruitment, that is with respect to allotment, and that is also with respect to promotion. There will be non-discrimination. But there is no fundamental right to claim for promotion. आप ये नहीं बोल सकते कि अब मुझे promotion भी चाहिए. You get that? Once you are recruited in any service, there is no fundamental right to seek for promotion. This is what the court has ascertained. So look here, in a May 2024 judgment, the Supreme Court of India reaffirmed that while government employees have the right to be considered for promotion, the act of promotion itself is not a fundamental right enshrined in the Constitution. Constitutional provisions related to reservation in India, obviously it is available to the scheduled castes, scheduled tribe, other backward classes, economically weaker section. Also there are provisions made with respect to, say, the specially abled or the disabled. Okay, so there is also something like that. Fundamental rights and reservation, Article 14, right to equality, guarantees equality before the law, equal protection of the laws. However, the state can make special provisions for disadvantaged groups. This is what, because likes should be treated alike. That is what the second part of Article 14 says. Then we have got Article 15. This is just a reiteration of your polity parts. So I've just included it here. All of these articles have come into news now. That's why please have an eye on them. Article 15(4), which allows the state to make special provisions for the advancement of SCs, STs and other socially and educationally backward classes. Article 15 clause 5 empowers the state to reserve seats in educational institutions, including private institutions except minority institutions for SC, STs and OBCs. 15(6) provides 10% reservation for EWS. Similarly, 16, if you see equality of opportunity in public employment, 16(4) allows reservation in government jobs for SC, STs and OBC. 16(4)(a), state can make any provision for reservation in promotions for scheduled caste and scheduled tribe in government job. This is obviously added by the 77th Constitutional Amendment Act. 16(4)(b) भी उसी से ही ऐड किया गया है. It enabled the unfilled SC, ST quota of a particular year to be carried forward to next year. पहले ऐसा होता था कि it cannot be carried forward for 3 years से ज़्यादा नहीं कर सकते, but now it can be carried forward to any number of years with respect to SC and ST. Article 16(6) introduced 103rd Constitutional Amendment Act, 10% wage reservation in jobs for EWS. Special provisions for scheduled castes and scheduled tribes and OBCs. Article 46, Directive Principles of State Policy, says directs the state to promote educational and economic interests of SC, STs and other weaker section. 330 and 332, 330 reserve seats in Lok Sabha for SC, STs. 332 reserve seats in state legislative assemblies for SCs and STs, and this reservation is with respect to the proportion of their population, with respect to the overall population. 335, which says that the state states that the scheduled caste and scheduled tribes should be, the reservation should be considered by keeping in mind the administrative efficiency of the government as well. Although the 82nd Constitutional Amendment Act has inserted a clause here as well, which now allows for lowering of the evaluation standards, qualifying marks, etc., to recruit the SCs and STs. As I told you that reservation is a top-down thing. Do you understand that? It will not yield results unless it is also supported by bottom-up approach, which is grassroots level development. And unfortunately, जब हम positive discrimination या affirmative action की बात करते हैं, we only focus on the top down in most societies. It has to be bottom up. Like you have to build schools, you have to think about the living standards of the people, decent employment, health, all those kind of things, and then you have to skill the people and you have to empower the people politically, socially, culturally, हर तरीके से empower करना पड़ेगा, and then they would become generators. Do you understand that? Rather than passive receivers. So passive receiver बना के रखने में जो है आप देखोगे politically फायदा हो सकता है, but development wise या nation के interest wise से कोई फायदा होगा नहीं. So यही problem है with respect to this. That's why you see that even the original constitution had so many provisions. All of them have been modified by successive amendments made to the constitution, and the entire efficiency thing has now been diluted. Again, special provisions for economically weaker sections, 15 clauses, 16(6), 10% reservation in jobs and educational institutions. 338A, establishment of National Commission for Scheduled Caste, National Commission for Scheduled Tribe. 340, which is the empowers the president to appoint a commission to investigate into the conditions of the other backward classes, like the Mandal Commission was appointed. Special provisions in certain states, 371, and special provisions for states like Nagaland, Mizoram and Assam allow preferential treatment in jobs and education for local residents. 9th schedule and protection of reservation laws. Obviously, you know that the Tamil Nadu Reservation Act, say for example, placed in the 9th schedule and cannot be questioned even if it is violating any of the fundamental rights, mostly 14 and 19, but can be challenged on the ground of the breakdown of the doctrine of basic structure. ठीक है, तो again key Supreme Court judgments on reservation, Indra Shawnee case 27% reservation जो OBC वाला मिला, then M Nagaraj case reservation and promotion for scheduled caste, and Supreme Court has said that this is not a fundamental right. Do you understand that? Then Jarnail Singh case removed the need for providing backwardness in SC/ST reservation in promotions. EWS reservation case 10% reservation does not violate the basic structure, because basic structure में जो 10% है, that is the 50% जो capping है इंदिरा शानी में जो किया था, which is caste based reservation. Do you understand that? And this is reservation over and above that. Got it? मतलब एक टाइम ऐसा आएगा कि अगर ये डेवलपमेंट ठीक से नहीं हो पाया और ये पॉलिटिक्स चलती रही तो सब रिजर्व हो. Do you understand that? सब आ जाएंगे रिजर्वेशन, तो जो रियल बेनिफिट्स जिनको मिलना चाहिए वो that will be lost, completely lost. Supreme Court's clarification on FIR and general diaries. You see, what is an FIR? Full form क्या होता है? First Information Report, right? FIR जब कोई cognizable offense हो तो FIR रजिस्टर करना मैंडेटरी हो जाता है. कॉग्निजेबल ऑफेंस क्या होता है? कॉग्निजेबल ऑफेंस वो होता है कि जहाँ पे पुलिस आपके खिलाफ एक्शन ले सकती है विदाउट कोर्ट्स परमिशन, मतलब अरेस्ट वारंट की ज़रूरत है नहीं, ठीक है, मजिस्ट्रेट के अप्रूवल की ज़रूरत है नहीं, आपके खिलाफ एक्शन हो सकता है. नॉन कॉग्निजेबल ऑफेंस में जो कोर्ट है उसका अप्रूवल लेना पड़ेगा बिफोर पुलिस एक्शन कैन बी इनिशिएटेड अगेंस्ट यू. गेट दैट? सो FIR जो है अब फाइल करना मैंडेटरी हो गया है विथ रिस्पेक्ट टू कॉग्निजेबल ऑफेंस. इसके ही अलग एक और चीज होती है जनरल डायरी. जनरल डायरी एक रजिस्टर है, ऐसे समझ लो, विच इज मेंटेन्ड इन द say the police chowkis, okay, police stations, where you will see that it will have all the records. If it's non cognizable offense तो आप वहाँ पे लिख सकते हो, cognizable offense है तो आपको FIR करना ही पड़ेगा. आप FIR रजिस्टर करने से मना नहीं कर सकते. Do you understand that? So there was a lot of controversy back because of this. Some police stations, they have refused to file their FIR and all. So that's why this is what the Supreme Court has observed, that in cognizable offences you have to file an FIR, okay, फर्स्ट इन्फॉर्मेशन रिपोर्ट। और यहाँ पर ही जो कॉन्सेप्ट आता है वो कॉन्सेप्ट आता है FIR का। एक और चीज़ है जीरो FIR, हैव यू हर्ड अबाउट इट? व्हाट इज जीरो FIR? हाँ, कहीं कहीं पे भी आप कर सकते हो, मतलब वो जरूरी नहीं आपके जुरिस्डिक्शन एरिया में आ रहा हो, आप बाहर भी जाके कर सकते हो। और जब आप करते हो उसको तो इन्वेस्टिगेशन फ्रेश स्टार्ट होता है कि किसी पुलिस स्टेशन में जहां तक हो चुका है वहां से स्टार्ट होता है? आपको समझ में आया मेरा क्वेश्चन? फ्रेश स्टार्ट होता है, याद रखो, ठीक है। जीरो FIR फ्रेश स्टार्ट होता है, इसलिए कोई कहीं भी अब FIR कर सकता है किसी के भी नाम पे, ठीक है। सो इन शैलेश कुमार वर्सेस स्टेट ऑफ यूपी, उस समय उत्तराखंड था, 2024, the Supreme Court of India has clarified the distinction between a first information report and a general diary entry, emphasizing their legal significance in criminal investigations. What is a cognizable offense? ये देख लो। A cognizable offense is a type of crime where the police have the authority to register an FIR, investigate and arrest the accused without prior approval of the court. A cognizable offense is a crime that a police officer can investigate and arrest without a warrant. The offences are generally serious in nature and pose a greater threat to society. Legal basis defined under section 2C of the Code of Criminal Procedure 1973. The classification is based on severity of the punishment and the impact on public order. Examples of cognizable offences: murder, rape, kidnapping, theft above 50,000, rioting with deadly weapons, etc. और ये sections लिखे हुए हैं सारे, ठीक है। Key features: police can register an FIR and start an investigation immediately. Arrest can be made without prior approval of magistrate. Punishment is generally imprisonment of more than 3 years, life imprisonment or death penalty in cognizable offences. आप ऐसे सोच सकते हो, cognizable offences are grave crimes and heinous crimes, right? They are cognizable offences. आपने वैसे ही सुना होगा कि bailable, non-bailable ऐसा भी होता है, cognizable, non-cognizable, ठीक है। Supreme Court's key ruling on FIR and general diaries. In Lalita Kumari versus Government of UP 2013 case, mandatory registration of FIR, the Supreme Court ruled that police must register an FIR if a cognizable offence is disclosed. Again, in State of UP versus Krishna Master 2010 case, the court emphasized that an FIR is the first step in criminal investigation, while a GD entry is just an internal police record. TT Anthony versus State of Kerala 2001, the court ruled that multiple FIRs for the same offence is not permissible, though different aspects of the crime can be covered under different FIRs. Do you understand that? But the same aspect cannot be covered under different FIRs. और अगर आपके नाम पे समझ लो कई जगहों पे FIR हो जाए तो आप ये कोर्ट पे जाके अपील कर सकते हो कि इन सबको मेरे होम स्टेट में ले आइए या किसी भी स्टेट में जहां आप चाहते हैं, ठीक है। पहले तो ऐसा कुछ काम करना ही मत। And then Mohammed Yusuf versus Afaq Jahan held that a preliminary inquiry recorded in GD cannot replace an FIR, and if a cognizable offence is made out, registration of an FIR is mandatory. अच्छा, मेरा एक सवाल है, ऐसे सोच कर देखो, किसी पुलिस स्टेशन में है और cognizable offence है, लेकिन उसने GD में एंट्री कर दी, जनरल डायरी, FIR नहीं फाइल किया, और आपको पता है FIR कब फाइल करना होता है? जल्द से जल्द। नहीं किया फाइल, तो क्या उसको अब एक FIR की तरह देख सकते हो GD में जो एंट्री की? Do you understand my question? Answer is yes. समझ में है? क्योंकि ये गलती है किसकी? पुलिस की। ये गलती जिस विक्टिम की थोड़ी ना है। तो किसी टेक्निकल फॉल्ट के लिए आप जस्टिस कैसे डिनाई कर सकते? तो ये चीज ध्यान में देखो, यहाँ पे लिखा भी हुआ है। In CBI versus Tapan Kumar Sena 2003 case, the Supreme Court ruled that a general diary entry may be treated as FIR in an appropriate case, where it discloses the commission of a cognizable offence. अगर बाद में जाके ये पता चल जाए कि ये cognizable offence था और जनरल डायरी में एंट्री कर दी थी तो वो FIR बन जाए। You get that? तो आप देखोगे कई बार अगर कुछ भी हो जाए, जैसे बहुत सारे लोगों के साथ होता है, फोन गुम जाता है, ये कुछ हो जाता है, तो पुलिस स्टेशन चले जाते हैं बिल्कुल, ठीक है, और बोलते हैं कि FIR लॉन्च कर दीजिए। ये बोलते हैं कि मेरा फोन नहीं मिल रहा है, FIR करिए। तो पुलिस भी उनको बिठाती है कि हाँ बेटी उधर चले जाइए, देखना एक रजिस्टर खोल के बैठते, अब बोलिए, ऐसे लिखते हैं, या तो फिर एक प्लेन पेपर पे लिखते हैं ऐसे, वो आपको दिल खुश कर, ठीक है, कुछ होना जाना है नहीं उसका। FIR मतलब वो एक फॉर्मल रिपोर्टिंग होगी, ठीक है, वहां पे जो भी आप बोलोगे उसकी वैल्यू है कोर्ट, ठीक है। बट एनीहाउ, ये डिफरेंस मैंने बता दिया आपको FIR और जनरल डायरी के बीच में. A formal complaint registered for a cognizable offence, a daily record of all activities and incidents at a police station. Section 1454 of CRPC, Section 44 of the Police Act 1861. Initiates an investigation into a cognizable offence, maintains a general log of events, complaints and routine police activities. Legally binding and requires police action, a non-binding internal police record. Any victim, witness or police officer who can file it. Police personnel can only record it. ठीक है, मतलब आप ये नहीं बोल सकते पुलिस की डायरी छीन के कि मैं आज एंट्री करूं. ठीक है. Contains details of offence, accused, time, place and complainant details, general police activities, routine complaints and reports. यहाँ पे ये भी बोलेंगे आपसे कि क्या हुआ था, किसके साथ हुआ था, कब हुआ था, आप कौन हैं, क्यों रजिस्टर करना चाहते हैं आप, ये सारे बहुत क्वेश्चंस हो. यहाँ पे कुछ नहीं, यहाँ पे आप जो बोलते जाएंगे वो लिखते जाएंगे. ठीक है. Triggers a formal criminal investigation, does not lead to an investigation but helps in documentation, and then can be used as a evidence in court, cannot be used as direct legal evidence in most cases. FIR, filing an FIR for murder, theft, rape or kidnapping, these are examples. Lodging a missing person report, lost items or local disturbances. ठीक है, कि हमारे मोहल्ले में कोई है बड़ा परेशान कर रहा है, ऐसा चले जाओगे तो वो नॉन कॉग्निजेबल होगा. Zero FIR, you already understand, right? Zero FIR means that can be registered by any police station irrespective of jurisdiction. No regular FIR number is assigned at this stage. और जो investigation है, it starts afresh and it was introduced on the recommendation of Justice Verma Committee following the 2012 Nirbhaya gang rape case. Okay, so yes, okay, yes, can be anyone. Okay, so FIR may mostly it's the start of the investigation, whereas general diary entry is just a record keeping work. Okay, that is the class. Yes, I'll take that question here. Hold on. What is not found suitable in reservation? Like, I did not understand your question. Clarify. Protesting. So this is a specific case, dear. Need to study that. How can I make a general statement? मतलब ऐसा है, मतलब मैं आपको पूछ रहा हूँ, बताओ राहुल की घड़ी कहाँ घूमी, तो वो केस लेकर. ठीक, yes, go on. Go on. कर सकते हो, नॉन कॉग्निजेबल के लिए भी कर सकते हो, बट कॉग्निजेबल के लिए जरूर होता है, करना ही पड़ेगा, मैंडेटरी है. गॉट इट? हाँ, लेकिन मैंडेटरी है कॉग्निजेबल ऑफेंस अगर हो गया, मैंडेटरी, क्योंकि वो क्रिमिनल एक्ट में. ठीक है, दैट इज इट, दैट इज आवर क्लास 1. ओके, आई विल शेयर द डॉक्यूमेंट. डोंट वरी, 18 क्लासेस हैं, अगर इतने भी टॉपिक्स करें 200 से ऊपर जा रहे हैं हमारे टॉपिक्स. ठीक है, और आने कितने हैं? 12, 10 से 12. उम्मीद करो इसी में से आ जाए. Thank you very much. See you in the next one.